Worker Protection Amendment of Equality Act 2010 Bill, second reading.
We're a whole house.
Thank you, Madam Deputy Speaker. I beg to move that the bill be now read a second time. I was very excited when I got onto place 15 out of 20 in the private members' bill ballot earlier in the year. My winning number was 461, the number I was given when I was first elected in 2017 as the 461st woman ever to be elected to Parliament. I owed it to my winning number to introduce a bill which would improve women's equalities, rights and protections. The bill in front of us doesn't only protect women from sexual harassment in the workplace, but all employees. However, the great majority affected by this new legislation will be women. Madam Deputy Speaker, I start by thanking the Fawcett Society and the Government's Equalities Office, who have worked tirelessly to draft this bill and for the many years of campaigning prior to that. My thanks go also to the Women's and Equality Select Committee, whose inquiry into workplace harassment led to a report published in 2018, which was influential in driving the proposed changes in the law. For too long, women and girls have been unsafe in the workplace. One Opium survey suggests that 20% of the UK population have experienced some form of sexual harassment in the workplace. That is over 10 million people, a shocking number. It is therefore right and imperative that the law changes to protect people in work. In these testing times, this legislation is more important than ever. Harassment is both unacceptably morally as well as it's bad for the economy. Evidence suggests that disrespectful and abusive work practices have lower performance and productivity and increased staff turnover. Even if you are not compelled by the moral reasoning behind increased protection from workplace harassment, it is hard to ignore the economic arguments. The 2018 President's Club scandal highlighted the extent to which people are currently unprotected by the law. In this instance, young female hostesses were allegedly sexually harassed by businessmen at a notorious men-only dinner, being instructed to wear black sexy shoes and black underwear. These women, who faced violations of their dignity, would not have had recourse to the law as it currently stands. Sexual harassment by third parties is a major problem in the UK. A 2017 survey suggests that 18% of those who had experienced workplace sexual harassment said the perpetrators were a client or a customer. 1.5 million people have been harassed by a third party, meaning clients or customers were allowed to harass 1.5 million workers. Workplace sexual harassment is widespread and widely underreported. A TUC survey suggests that 79% of women do not report their experience of sexual harassment. This happens for many reasons, including fear of repercussions, lack of awareness regarding their rights, and fear of not being taken seriously. These concerns are heightened for people of colour, people in the LGBT plus community, and people with disabilities who already face greater discrimination in the workplace. It is understandable why people do not come forward. For one, it is not just third parties who harass people, with 20% of surveyed women suggesting that their direct manager or someone else with direct authority was the perpetrator. It therefore goes without saying that any reporting could have direct career implication for those involved. Furthermore, whether the sexual harassment is via a third party or not, employers have not done enough to prevent and punish it. The Equality and Human Rights Commission found in nearly half of the cases where employees were made a report, the employer took no action, minimized the incident, or placed the responsibility on the employee to avoid the harasser. It seems the risk of reporting sexual harassment can outweigh the merits. This is disgraceful in modern Britain. The problem is that the current laws on sexual harassment mean employers often adopt individual responses to institutional problems. This creates space for employers to minimize what is going on and leads to confusion around how to respond appropriately. Statistics show that only 45% of managers felt supported by their organization when reports were made to them. Ultimately, the current laws leave people who have encountered traumatic experiences unsupported. We can and must do better. The government itself agrees that more needs to be done to tackle sexual harassment in the workplace. In its 2021 response to a consultation on workplace sexual harassment, the government committed A, to introduce a new preventative duty for employers, B, introduce more explicit protections from harassment by third parties, and C, support the Equality and Human Rights Commission to develop a new statutory code of practice on workplace harassment. For things to improve, there needs to be a shift in focus from redress to prevention. Currently, the question of whether employers have taken adequate steps to prevent sexual harassment only arises as a defence if an incident of sexual harassment has already occurred. This means employers are not required to take actions that prevent sexual harassment. Indeed, the Equality and Human Rights Commission found in 2018 that only a minority of employers had effective processes in place to prevent and address sexual harassment. This bill would provide the shift in focus that is so desperately needed. Clause 2 will ensure that employers prioritise prevention by imposing a new duty on them to take all responsible steps to prevent their employees from experiencing workplace sexual harassment. This will not require employers to do anything substantially more than what they currently must do to avoid legal liability for acts of harassment carried out by their employees. However, it will mean that employers could potentially be further held to account if they have failed to take those actions. Firstly, through an uplift to the total compensation awarded at an employment tribunal, and secondly, through the Equalities and Human Rights Commission's strategic enforcement. This will hopefully push employers towards prioritising prevention of sexual harassment, including through improving workplace practices and culture. The new duty will operate through dual enforcement. The Equality and Human Rights Commission may take enforcement action for a breach or suspected breach of the duty under their strategic enforcement policy. This would mean that women would be able to inform the Equalities and Human Rights Commission of any concerns without necessarily having to take forward legal action against their employer. In addition, the employer's duty will be enforceable by the employment tribunal in individual cases. Where the employment tribunal has found in favour of an individual claim of sexual harassment and has ordered compensation to be paid, the tribunal will examine whether and to what extent the duty has been breached. Where a breach of duty is found, tribunal judges will have the power to order an uplift of up to 25% of the compensation awarded. The bill will also introduce explicit protections against third-party harassment in the workplace. Clause 1 would make employers liable for the harassment of their staff by third parties, such as customers and clients, where they have failed to take all responsible steps to prevent such harassment from happening. These protections will apply to all acts of third-party harassment in the workplace, including racial as well as sexual harassment. Once again, there will be a system of dual enforcement. Individuals will be able to bring claims to an employment tribunal in the usual way for work-related cases under the Equality Act 2010. The Equality and Human Rights Commission will have strategic enforcement powers. Compensation will be assessed in the usual way for Equality Act's claims, with the same uplift outlined earlier available in cases where a breach of duty has also been established following a successful third-party sexual harassment case. A claim for third-party harassment could be brought after a single incident of harassment. This replaces the previous 3 strikes formulation, whereby employers needed to know of 2 previous incidents of third-party harassment before they could be considered liable. But employers will be able to rely on the all reasonable steps defence in the usual way. To ensure employers are as informed as possible about the proposed changes, which will come into force 12 months after royal assent, the Government's Equality Office will support the Equality and Human Rights Commission in creating a statutory code of practice on sexual harassment and harassment in the workplace. This will be based on the technical guidance the Equality and Human Rights Commission published in 2020 and will be introduced as the new legislation comes into force. The Equality and Human Rights Commission will have a duty to consult on this code of practice in advance. In the meantime, the Government Equalities Office has produced guidance for employees on how to prevent sexual harassment, which I understand they are looking to publish in due course. Madam Deputy Speaker, let me finish by turning away from the technical details of this bill and return to the wider set of circumstances that makes it important for us to pass this legislation. An unacceptable number of nurses, paramedics, bar staff, people who were key workers during the pandemic, and everyone in between are being subject to a form of harassment which causes a variety of harms, including psychological, physical, and economic harm. Employers should be required, both morally and legally, to take all reasonable steps to stop sexual harassment from occurring. The fact that the law of this country does not compel them to do this is a concern. For too long, the onus for challenging sexual harassment has been on individuals. Our current laws mean employers do not know how to respond to cases appropriately and leaves people who have encountered traumatic experiences unsupported. Introducing a standalone preventative duty for employers will shift the responsibility from individuals to the institution. It will prevent harassment and protect victims, and it will drive a change in the culture around victim blaming. I urge that this House supports my bill enshrining in law historic measures to protect employees from harassment in the workplace. And I want to thank everybody across the House who has given support to this bill and has already committed to serving on the bill committee that will make sure that this bill will progress through the House. Thank you, Madam Deputy Speaker.
The question is that the bill be now read the second time. Bob Blackman.
Thank you, Madam Deputy Speaker. And I rise to support the bill in the name of the Honourable Member for Bath. The reality is that we as MPs don't work regular hours. We work incredibly long hours, as we all know. But most people are working between 37.5 hours and 40 hours on average a week. And it's absolutely right that they should feel safe in the workplace in which they're working. So I welcomed the 2010 Equality Act and the employer liability it implemented. But unfortunately, situations are still rising and the Act now needs to go further on protecting employees. Where employees are given appropriate support when sexual harassment takes place, that's extremely welcome, but it's far too infrequent and we need to encourage it. I therefore encourage the removal of the 3-strike rule. As Madam Deputy Speaker, we all make mistakes at times. Actually owning up to them and apologising is a very good way of ameliorating that mistake. But when people are committing sexual harassment, that's not a mistake, that's predators. And we should call it out for what it is. And we must not allow it to continue. So the fact that employees at the moment may have to suffer 3 strikes before action is taken is completely unacceptable, and a single time is once too many. So it shocked me to hear that 79% of women do not report sexual harassment in the workplace because they fear repercussions, losing their job or losing their livelihood. So we've got to make that change, and I welcome the bill that will enable that to happen. But we should also remember that it's not just women that suffer sexual harassment in the workplace, it's men as well. And therefore we must make sure these things are covered. And in most cases, men are very embarrassed to report sexual harassment. And we have that classic British upper stiff lip, which actually leads then to the rising of concerns of men's mental health and the rise in suicide that can follow. So I think it's important that employers take preventative measures to prevent the position of these of sexual harassment taking place. And the clause that is in the draft bill on such measures, very welcome. And if an employer breaks the duty, they should pay for it, because it's their responsibility to make sure everyone is safe and protected. So I trust that after this bill is passed by this House and the other place, what we'll see is the number of cases falling rapidly and everyone can feel safe in the workplace, because no one should fear having to come to work and suffer harassment. I support the bill.
Imran Hussain.
Thank you, Madam Deputy Speaker. And can I also start by thanking the Honourable Member for Bath for bringing this very important bill here today, and she spoke, I believe, very well to make the case for the great need for this change in legislation. Madam Deputy Speaker, I will be very brief with my remarks because I'm very keen for this bill to progress to the next stage. Last year, the Fawcett Society released harrowing research into sexual harassment in the workplace, which shows that despite the bravery of the Me Too movement in coming forward to challenge the abuses of power by employers and others in the workplace, harassment, and particularly sexual harassment, remains a deeply concerning problem that should worry all of us, with 2 in 5 women reporting that they have faced harassment in the workplace. What's more, a report from the Government Equalities Office has indicated that 80% of women who have faced harassment in the workplace do not go on to report it. Madam Deputy Speaker, I'm sure that all of us on either side of the House are committed to stamping out this abhorrent behaviour, this abhorrent views, and on this side of the House we stand committed to this bill. After all, it is a bill that, by making employers liable for harassment committed by clients and customers, reintroduces the provisions that the last Labour government introduced under the Equality Act 2010, but which the Tory-led coalition government in 2013 ditched, claiming that these protections imposed an unnecessary burden on business. Let me be clear, protecting people from harassment and protecting them from harassment in the workplace is never a burden. It is a responsibility, and in the 9 years since first removing this protection, it is welcome that the government have now finally realised the error of their decision. However, we should not have had to wait for so long for them to do so, especially given that, like so many of the initiatives of this government, they launched a consultation on strengthening protections against harassment in the workplace back in 2019. Madam Deputy Speaker, we support this bill today, but I want to repeat that the government should never have repealed these important protections for working people, and we should be in a place where we're dramatically extending the protection that is already available rather than having to actually reintroduce it as well.
Minister Catherine Fletcher.
Madam Deputy Speaker, firstly, can I congratulate the Honourable Member for Bath for bringing forward this important bill, as well as all the Honourable Members who've spoken in this brief, but I would argue important debate. The significance of the issues which this bill addresses cannot be overstated. The survey in 2010 from the Government Equalities Office found nearly 3/4 of people had been affected by sexual harassment in their lifetime, whilst 2 in 5 had experienced it within the last 12 months. And in the world of work, the rates remain unacceptably high, with 29% of people in some form in the last 12 months, and that's nearly 1 in every 3 members. So it is rather auspicious today that this debate has fallen on the week coinciding with the 5-year anniversary of the Me Too movement going viral. On 15th of October 17, the words Me Too were shared on Twitter by 12 million people around the world, me included, and this government believes that that's important and has taken significant steps to combat sexual workplace harassment in the past 5 years. We've had the implementation of the strategy of violence against women and girls. The UK has ratified 2 important international treaties, the Istanbul Convention on Preventing and Combating Violence Against Women and Domestic Violence, and the International Labour Organisation's Convention on Violence and Harassment, the first international treaty to recognise everyone's right to a workplace free from violence and harassment, and the UK will continue to work to lead the world in this area. It's also important to recognise, as we've heard, that workplace harassment is an issue that can affect anyone, regardless of industry, profession, age, race, sex or sexuality. Anyone can be a victim, with men reporting almost similar levels of harassment, as has been highlighted in the debate today. The government is therefore very pleased to both share and support this bill, and whilst there is already a robust legal framework against workplace harassment in the Equality Act 2010, the measures contained here provide an important strengthening of these protections and a renewed focus on prevention, which we will hope lead to a reduction in workplace harassment across the country. We've listened carefully, and I'm extremely keen to see this bill progress. So I just want to say, I think the Honourable Member for Harris was correct to highlight that it's not just women that are affected, and we need to protect employees from predators. I would like to thank the honourable member for bringing it forward today. This bill is an important step change in the protections available from workplace harassment, and as the debate from future workplace proceeds post-pandemic, this government is committed to make sure everyone feels safe and supported to thrive. We strongly support this bill. Thank you very much.
Vera Hophouse.
Well, I want to thank everybody for their support of this bill. As has been said, this is not just affecting women, it affects anybody who is in work, and they should be protected from harassment. It should particularly introduce a culture change so the harassment at the workplace is a thing of the past. Thank you to everybody across the House, and I'm looking forward to the progress of the bill.
The question is that the bill be now read a second time. As many as that opinion say aye. Aye. Of the contrary, no. I think the ayes have it. The ayes have it.